Good morning, sir, and good morning, buddies. So for today, we're going to report Article 100 to 113, and we are the Group 9 presenters.
The sequence of the presentation, Article 100 to 113.
The topic learning objectives. First, discuss the general rules of civil liability. Second, to understand the difference between restitution and reparation. Third, from Article 100 to 113, students will learn the exemptions to implied institution of civil action, the exceptions of restitution, the definition of indemnification, obligation to make restitution in certain cases, extinguishment of civil liability, and the obligation to satisfy civil liability.
The overview and introduction of these articles. This presentation tackles about Article 100 to 113 under Criminal Law in the Revised Penal Code Book 1. Subsidiary civil liability. Parents, teachers, employers, and proprietors shall be subsidiarily liable for the crimes committed by their children, students, employees, and servants. Exemptions of restitution. If the innocent purchasers acquire the said property in the public sale, then it can no longer be taken away from him. Indemnification includes moral damages, civil indemnity, exemplary damages. Moral damages in case of rape or murder need to not be proved. It suffices that the crime has been committed. The law presumes that the victim suffered moral indemnity because of the crime committed. The subsidiary liability shall be enforced, first, against the property of the principals, next, against that of the accomplices, and lastly against that of the accessories. Civil liability shall be extinguished by the following acts. First, by pardon of the offended party. Second, other modes for extinguishing civil liability under civil code, payment and condonation.
Good day again, sir and buddies. This is the report of Group 9, and I am Francis and Walter Sumayang. I will be the first one to report in this group. My topic is Article 100, the civil liability of a person guilty of felony. So every person criminally liable for a felony is also civilly liable. Civilly liability. As a general rule, every person criminally liable is also civilly liable. For every criminal action filed in court, the civil action for the recovery of civil liability is deemed implicitly instituted. So, what is the reason? The reason, the commission of a crime. There are two injuries are inflicted: the social injury and the personal injury. Social injury against the state for the disturbance of social disorder, and personal injury against the offended party and his heirs. The social injury against the state will be answered by reparation. Personal injury will be answered by the civil indemnity. Next buds. So there are exemptions to implied institution of civil action. And these are the following exemption to the general rule. A general that a civil action is implicitly instituted in a criminal case. Number 1, when offended party waives the civil action. Second, when the offended party reserves the right to file a separate civil action, which must be prior to the presentation of evidence of the prosecution. And lastly, when the offended party files the civil action prior to the criminal action. And acquittal effect on civil liability. In the following cases, acquittal na criminal action bars recovery in civil action. Number 1, if the judgment of acquittal states that the alleged criminal acts of the offender were not committed by him. Number 2, if the judgment of acquittal states that the accused is not guilty of criminal or civil damages. In the following cases, the acquittal of the accused in a criminal case is not a bar to recover civil liability. Number 1, when judgment of acquittal is based on reasonable doubt. This is because civil action requires mere preponderance of evidence. Number 2, when judgment of acquittal states that the liability of accused is not criminal but civil in nature. This usually happens when the case is estafa and there is a contract between the accused and complainant, upon which the accused failed to comply with the terms of the contract. This is breach of contract. Number 3, when the judgment of acquittal states that the civil liability does not arise from the crime but from other sources of obligations.
The Article 101. Rules regarding civil liability in certain cases. The exception from criminal liability is established in subdivision 1, 2, 3, 5, and 6 of Article 12, and in subdivision 4 of Article 11 of this code does not include exception from civil liability, which shall be enforced subject to the following rules. Rules. First, in cases of subdivision 1, 2, and 3 of Article 12, the civil liability for acts committed by an imbecile or insane person and by a person under 9 years of age or by 1 over 9 but under 15 years of age who has acted without discernment shall devolve upon those having such person and under their legal authority or control unless it appears that there was no fault or negligence on their part. Should there be no person having such insane imbeciles or minor under his authority, legal guardianship or control, or if such person be insolvent, said insane, imbecile, or minor shall respond with their own property, excepting property except from execution in accordance with the law. So the first is talk about it's talk about the minor, insane, or imbecile person and by a person under 9 years of age or by 1 over 9 but under 15 years of age who committed a crime, they will be exempted or they will not criminally responsible in accordance with the civil law. Next is second. Second, in cases falling within subdivision 4 of Article 11, the person for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefits which they may have received. The court shall determine in sound declaration the proportionate amount for which each one shall be liable. When the respective shares cannot be equitable, determined even approximately, or when the liability also attaches to the government or the majority of the inhabitants of the town, and in all events, whenever the damages have been caused with the consent of the authorities or their agents, and their indemnification shall be made in the manner prescribed by the special laws or regulations. The second is talk about the subdivision 4 of Article 11. It means that the person commit a crime that harm the people or person shall be criminally liable, or shall we say pay for the damages. The court will determine the proportion each one shall be liable, and also if the person attaches to the government whenever the damages have been caused with the consent of the authority, and their indemnification shall be made in the manner prescribed by special laws or regulations. Third is, in cases falling within subdivision 5 and 6 of Article 12, the person using violence or causing the fear shall be primarily liable, and secondarily, or if there be no such person, those doing the act shall be liable, saving always the latter that part of their property except from execution. The third is talk about the person using violence or causing the fear. It shall be liable. If there's no such person, those doing the act shall be liable. Next one. Insane, imbecile, minor. In cases the offender is insane, imbecile, or minor, the civil liability arising from their act shall be shouldered by the person who custody of the insane, imbecile, or minor. Secondary liability falls on the property of the insane, imbecile, or minor, except these properties which are prohibited from being attachment. It means that the offender have the the offender is insane, imbecile, who commit a crime, or minor, they will not be criminal liability. State of necessity. Necessity means is needs. All persons who have been benefit during the state of necessity shall bear the civil liability. If there are many persons benefited, the liability shall be divided by the court proportionally. In irresistible force or uncontrollable fear, borne by the person who enforced the threats of the to the offender. Secondary liability falls upon the principal by direction participation, who is the one who acted under the compulsion of irresistible force or uncontrollable fear. If it means that if the offender have been threatened and the one who acted under the compulsion of irresistible force or uncontrollable fear, secondarily liability tells upon the principal by direct participation. Article Next is Article 102. That article will explain Batch Douglas.
Good morning, sir. Good morning, buddies. I am Cadet Douglas Douglas. In default of persons criminal liable, innkeepers, tavern keepers, and any other persons or corporations shall be civilly liable for the crimes committed in their establishment. In all cases where a violation of a municipal ordinance or some general or special police regulations have been committed by them or their employees. Under paragraph 1 of Article 102, innkeepers, tavern keepers, and proprietors of establishments are subsidiarily liable when all of the following elements are present. The innkeepers, tavern keepers, and proprietor of establishment or his employee committed a violation of a municipal ordinance or some general or police regulation. Second, a crime is committed in such inn, tavern, or establishment. Third is the person criminally liable if insolvent, meaning bankrupt. When all of the following elements are present, the innkeepers are subsidiarily liable for the restitution of goods taken by robbery or thief within their houses, from guest lodging, or for payment of the value. The guests have notified in the advance the innkeeper or the person representing him of the proceeds of their goods within the inn. The guests have followed the direction of the innkeeper or his representative with respect to the care and vigilance of their goods. Such goods of the guests lodging in their were taken by robbery or thief. Even if the guests did not deposit their goods and a notice of disclaimer of the liability was posted in a hotel, it does not free the owner from subsidiary liability. It is enough that the goods were stolen within the inn. The next is Article 103.
Article 103. Subsidiary civil liability of other person. The subsidiary liability established in the next preceding article shall also apply to employees, teachers, persons, and corporations engaged in any kind of industry for felonies committed by their servants, pupils, workmen, apprentices, or employees in the discharge of their duties. So the subsidiary liability in Article 103 should be distinguished from the primary liability of employers, which is quasi-delictual in character as provided of the new Civil Code. Under Article 103, the liability emanated from a delict. On the other hand, the liability under Article 2180 is founded in culpa aquiliana. The present case is neither an action for culpa contractual nor for culpa aquiliana. This is basically an action to enforce the civil liability arising from crime under Article 100 of the Revised Penal Code. Subsidiary civil liability. So, in this paragraph, in order for an employer to be found partially accountable for an employee's civil culpability in a criminal case, it must be established that the employer is involved in the relevant industry and the employee committed a crime while performing his duties and the employee is bankrupt. So, once the employee is found guilty and it is established that they are insolvent, the employer is automatically held subsidiary accountable. Furthermore, we are not persuaded that the owner-operator was denied a fair trial because in the case at hand, the operator is not being sued for a primary civil code violation rather than the civil liability incident to the dependent upon his employee's criminal negligence in being sought to be enforced. The subsidiary liability of employers is in the fact that the substance of the party to the criminal prosecution in the subsidiary culpability mandated by law. It is included by the determination and enforcement of the employer's subsidiary obligation in the criminal case. So the proceeding for the enforcement of the subsidiary civil liability may be considered as the part of proceeding for the execution of the judgment. A case in which an execution has been issued is regarded as still pending so that all proceeding on the execution are in the suit. There is no question that the court which rendered the judgment has the general supervisory control over its process of execution and this power carries with the right to determine every question of fact and law which may involve in the execution. These are the examples under Article 103. Ipadaan slide B to 104. Article 104. What is included in civil liability? The civil liability established in Articles 100, 101, 102, and 103 of this code includes restitution, reparation of damage caused, indemnification for consequential damages. So the Article 104, the Revised Penal Code fleshes out the civil liability in other article which states that it includes restitution, reparation of damages caused and indemnification of consensual damages. The first which is restitution. The thing itself shall be restored even though it be found in the possession of the third person who has acquired it by lawful means, saving to the latter his action against the proper person who may be liable to him. This provision is not applicable in any cases in which the thing has been acquired by the third person in the manner and under the requirements which by law bar an action for its recovery. The second one is balik daw tong sa Article 4B. The second one is the reparation of the damage caused. This means that the court shall determine the amount of the damage taking into consideration the price of the thing, whenever possible, and its special sentimental value to the injured party, and reparation shall be made accordingly. The third one is indemnification for consequential damages. This means that the damages shall include not only those caused the injured party but also those who suffered by his family or by the third person by reason of the crime. This article has the action to demand restoration, reparation, and indemnification likewise descends to the ears of the persons injured. The next article will be discussed by Cadet.
Article 5. The restitution of things itself must be what? Whenever possible, when allowance for a deterioration of domination of value of determined by the court. The thing itself shall be restored even though it be found the possession of a third person who has acquired it by lawful means, saving to the its action against the proper person who may be liable to him. This provision is not applicable in case in which the thing has been acquired by third person in manner of under the requirements which by law bars an action for its recovery. Example of this topic include a shoplifter who is ordered by repay a store owner for the cost of stolen item. On our assailant who must pay for their victims' medical expenses after a violent assault. Its homicide cases restitution can even cover funeral costs. That's all.
Good morning, buds. My topic is Article 106. Reparation. The court shall determine the amount of damage taking into consideration the price of the thing whenever possible and its special sentimental value to the injured party, and reparation shall be made accordingly. Notes that reparation will be ordered by the court if restitution is not possible. Reparation shall be number 1, the price of the thing, number 2, its sentimental value. So, in case in case of inability to return the property stolen, the culprit must pay the value of the property stolen. The court shall determine the value of the thing taken, including its sentimental value. So, this topic focus on damage in one person or first contact with the offended party. Next batch. Identification. What is included? Indemnification for consequential damage shall include not only those caused the injured party but also those suffered by his family or by third by a third person by reason of the crime. Ang consequential damage is our moral damage, civil indemnity, exemplary damages. So, moral damage in case of rape or murder need not be proved. It emphasizes that the crime has been committed. The law presumes that the victim suffered moral indemnity because of the crime committed. Exemplary damages is punitive damages or exemplary damages. These are damages requested or awarded in a lawsuit when the defendant's willful act were malicious, violent, oppressive, fraudulent, wanton, or grossly reckless. Exemplary damages can be only granted if there are aggravating circumstances in the commission of the crime. That's all, but
The Article 108. Obligation to make restoration, reparation for damages, or indemnification for consequential damages and actions to demand the same, upon whom it devolves. The obligation to make restoration or reparation for damages and indemnification for consequential damages devolves upon the heirs of the person liable. The action to demand restoration, reparation, and indemnification likewise descends to the heirs of the person injured.
Article 109. Share of each person civilly liable. If there are two or more persons civilly liable for a felony, the courts shall determine the amount for which each must respond. If there were two accused convicted insofar as the civil liability is concerned, it is the court shall determine the civil liability of the two accused. This article will en- such is this article will enforce liability that can be subsidiary in every person that constitute the decision of each person, and it becomes incumbent by the subsidiary liability.
The Article 110, which is the several and subsidiary liability of principals, accomplices, and accessories of a felony, preference in payment. Notwithstanding the provisions of the next preceding article, the principals, accomplices, and accessories, each within their respective class, shall be liable severally in solidum among themselves for their quotas and subsidiaries for those of the other persons liable. The subsidiary liability shall be enforced first against the property of the principals, next against that of the accomplices, and lastly against that of the accessories. Whenever the liability in solidum or the subsidiary liability has been enforced, the person by whom payment has been made shall have a right of action against the others for the amount of their respective shares. Article 111. Obligation to make restitution in certain cases. It states that any person who has participated gratuitously in the proceeds of a felony shall be bound to make restitution in an amount equivalent to the extent of such participation.
So, sir, due to the absence of our other group mates, we will be the one who will report their part. Article 112. Extension of civil liability. Civil liability is established in Articles 100, 101, 102, and 103 of this code shall be extinguished in the same manner as obligation in accordance with the provision of the civil law. The extinguishment of civil liability. Civil liability shall be extinguished by the following acts. These are the two acts of the civil liability under the extinction of the civil. First, by pardon of the offended party. Second, other modes for extinguishing civil liability under civil code or payment or condonation. Civil liability is a personal and cannot be extinguished by pardon, amnesty, probation, commutation of sentence, and etc. Civil liability can only be extinguished in the same manner as in the civil law by the extinguishment of obligations, payment, loss of the thing, remuneration, and compensation. Article 113. This is the last article. Obligation to satisfy civil liability. Except in case of extension of his civil liability is provided in the next preceding article, the offender shall continue to be obliged to satisfy the civil liability resulting from the crime committed by him, notwithstanding the fact that he who has served his sentence consisting of deprivation of liberty or other rights, or has not been required to serve the same by reason of amnesty, pardon, commutation of sentence, or any other reason.
So in conclusion, In this jurisdiction, it is the rule that all civil and criminal obligations stemming from felonies and misdemeanors must be resolved in the same case. In the Philippines, there is no such regulation. All those who are legally responsible for crimes and offenses on both a civil and criminal level should be summoned to court so they can present their defense in order to prevent the multiplicity of acts. Such individuals are all legitimate parties. The Civil Code refers to the Penal Code as a rule applicable in the first place because the latter determines and punishes the acts giving rise to said obligations or creates said obligations, so there is no legal reason why there should be more than one action to settle both the criminal and civil liabilities. In those mutual references of one legislation to another, there is no doubt as the application of one or the other, and they cannot be criticized because they are well founded. And that would be all, sir. Thank you.